Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers and the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy.
Hi, today I have with me Ashleigh Wagner from Kizzy Law, and I wanted to say thank you so much for being with me.
Absolutely. Thank you for having me.
My pleasure. I want to talk to you about a really specific topic that where me working with a bunch of different family law attorneys and a bunch of different clients doing different things. The topic that comes up a lot is consequences. So you have the judgment and it says, we agree to do this, we agree to do this, we agree to do this. I mean, granted, maybe it would be 100 pages long if it addressed every issue, but the issue of if you don't do this, this is what happens doesn't seem to come up very often on a lot of the judgments that I read. And then we end up into what I'll call post-divorce issues. And then what does somebody do? Like if somebody didn't move out on the right day, is that a big deal versus somebody's refusing to move out at all? You know, there's different things that come up. And so what is somebody supposed to determine? When do you contact your attorney? When do you go back to court? When's it worth it to do something? So if you don't mind kind of putting your attorney spin on it,
Yeah,
that would
absolutely.
be really helpful.
Of course. And I think that also, just as kind of a segue into that, speaks to the importance of having a detailed judgment of divorce that kind of addresses every step. And I think that most commonly comes up like issues with the home, or other property items where you need kind of a sequence of steps on how you're going to transfer an asset or retitle an asset. Because if you just simply say, so and so is keeping the home and that's it, then you're kind of setting yourself up for post-judgment litigation. But what happens when you do have a detailed judgment, or even with a detailed judgment, and one party's not doing what they're supposed to, you have an enforcement issue. And we do, I mean, probably, I would almost venture to say 50% of practice is post-judgment work for family law practitioners, because we have various property issues where someone needs assistance to go back to court. You basically have to file a motion for enforcement, and you have to, tell the court what the issue is. So kind of following the house example, say that someone is keeping the home, they have a requirement to refinance a mortgage and to pay out the other person one portion of the equity, and they have a timeline. Usually you have, 60 days, 90 days, that timeline's come and gone, and that person's not complying, or they're not able to do it. Either way, there's an enforcement issue. And so at that point, you would want to contact your attorney, file a motion to enforce, and there's typically repercussions to that. Oftentimes, we include a provision in our judgment that specifically references enforcement. And it says if you do have to bring that other party back to court because they're not complying with what they already agreed to do, then they're possibly on the hook for attorney fees. Sometimes we even include more like stronger language that says they shall be on the hook for your attorney fees. Of course, that's still up to the judge's discretion. And I will say that sometimes even with that strong language, you don't get, a one-for-one exchange. But it's always a possibility that if you're not complying with the judgment and you don't have a good reason or any reason, then you're going to be paying for the attorney fees of the party who had to bring you back to enforce that issue. So that's pretty common. Sometimes it doesn't matter how specific your judgment is, that person's going to be difficult.
Right. I have two actually right now where the person I'm working with is the one who was supposed to refinance in a timely fashion. And there is hurdle after hurdle after hurdle, or they try to do an assumption and they couldn't, and then they went somewhere else and they couldn't, and then, you know, the attorney says, come to me, and then I'm already like way past the deadline when I even get started. And I know I always wonder, like, am I going to do all this work and get it ready to happen and then be like, you're past your deadline, and now somebody's doing something about it.
I mean, I think it's pretty fact specific in that scenario. I mean, I've definitely had that situation, and you bring it to a judge and it sounds like that party that you're working with is trying to do what the judgment says. So I think that's kind of a different situation where the judge might allow them some additional time.
Okay.
As opposed to someone who, you know, has been just outright denied on a refinance or an assumption, or just hasn't even started the process.
What about a lot of people that they said they had to refinance, but interest rates were really low? So the two parties kind of like sidebar agreed that they could just keep things as they are. Is there at some point in time, if nothing's in writing, one of the parties could say, yeah, I let it go for a year, but now I want to enforce it?
Yeah, in theory, we include a provision in our judgment that says modifications of the judgment have to be in writing. They're only valid if they're in writing, and that would be, you know, a stipulated or a consent order post judgment. So, I mean, you can still present evidence as a defense that there was a verbal agreement or there was an exchange of emails or whatever the case may be, but that might not help you ultimately. Or it could just be, well, the other party agreed to this for a period of time because of interest rates or something like that. I know that I've had many cases where we've left the language somewhat vague as far as timeline to allow for interest rates to come down, because both parties recognize that. But I wanted to, you know, I make sure in those situations to reference that explicitly if I can.
Yeah, there was a good 2-year time period where no one was refinancing because we all thought rates would come back down.
Yeah.
And then of course they never came back down.
Right. And that's, I'm sure, caused a lot of issues. And
right. And the government kept saying, we're going to lower rates, we're going to lower rates. And then it just didn't happen.
Yep. Yep. I know a lot of people are in that boat. And that's why, not to be, you know, kind of harsh, but that's why it's also good to, as a practitioner, include in your judgment that when that timeline passes, whatever that timeline is, or if there's some default, that you just have to sell because you can't go on indefinitely.
Right. Right. And then I think, I don't know if this is something you could talk about too, but I know the way that you hold title, you know, and then if someone has to refinance and they don't, so then a deed never got redone, people probably aren't thinking of that either.
Right, right. The quit claim deed is usually tied into the refinance and buyout process. So if there's this, you know, languishing period of time and the quit claim isn't being transferred, then someone's can potentially be on the hook for property taxes. You know, there's all sorts of implications that I think people go into it with good intentions. They're trying to recognize the other party is going to be refinancing at a much higher interest rate than what they probably secured initially. So they're trying to be helpful. But there's, you know, that can, like I said, it can go on indefinitely, seemingly at this point.
Right. I guess it's our job, right, to always think of the what if.
Yeah, unfortunately.
So besides property stuff, what's another big area that comes up post-divorce?
Okay, so custody, parenting time, child support, all the children's issues are always modifiable. So, and they're modifiable based on a change in circumstances or proper cause. So when you finalize those provisions in your judgment of divorce, chances are you're going to still be, things are going to happen in the future that are not going to remain the same, especially if you have young children. A parenting time schedule that you might agree to when your kids are 2, 3, 4 is not going to be your parenting time schedule likely when they're 17. Just things happen. Another common obvious future occurrence is a change in income, which could impact a child support award that you originally agreed to. So those things are probably the vast percentage of what we go back to court post-judgment to deal with because they just inherently change. So we're talking about, you know, school issues coming up. Child support's a common one. a modification of a parenting time schedule that no longer is in the children's or child's best interest. Unfortunately, sometimes negative things happen that parent might need to lose parenting time or reduce their parenting time. So those are very, very common and always on the table. Whereas conversely, property issues, you're going back to court, those are figured out. You've already addressed them, but you might need to enforce them. The custody, parenting time, child support, you might need to modify them or enforce them. You can still enforce them, but more often than not, it's modifying.
Modifying them and somebody not paying or not paying on time.
Yes, and that would be an enforcement issue too, not paying child support or spousal support for that matter. That could be an enforcement issue.
And if someone doesn't pay, the person supposed to be receiving the money doesn't get it until they do pay, correct? It's not like they still get the income.
Right, right. So child support is generally paid through an income withholding order through the front of the court if you have a W-2 employee who's the payer. So if they're not able to pull it because, maybe someone loses their job, then that's when the front of the court will, after a certain period of time, initiate their own show cause proceedings. So I will say you don't necessarily need, that's a good point, you don't necessarily need an attorney for enforcement of child support, because if you have an order through the court, they have their own enforcement mechanisms in play.
And what if they don't go through front of the court? Does that matter?
If you don't go through front of the court, well, I guess there's two answers to that. So if you opt out of front of the court services, then no one's keeping track of your child support but you.
Okay.
Which is why we caution against that typically. So if you do have an enforcement issue, you first have to file a motion to opt back into front of the court and then file a motion to enforce. And you have to provide all the paperwork showing this is what I wasn't getting paid, because they have no idea. So it's an extra hurdle for sure.
That's interesting. I never put two and two together there, but I know a lot of people don't like to do front of the court. For mortgage purposes, I love front of the court because everything's online. It's really easy to verify stuff. But sometimes
it's something that people, I don't think, really realize when they come to us asking to not go through front of the court is like, what does that actually mean? I think you think, oh, there's this oversight, there's this agency making decisions about my children. In reality, they don't want to be involved. They're the enforcement arm for those issues if you need them. So they will quietly be in the background, happily. Making sure that everything's going okay. And if you need them, they're there. So not necessarily a downside to having them as an option.
Right. They have a bad rap for some reason.
Yeah. I think they do. I think that's fair.
I think they do too. Anything else or any other examples that you can think of that might come up post-judgment?
So another area that probably doesn't come up as much as the other two categories, which is property and children's issues, is spousal support. So spousal support is either modifiable or non-modifiable, and that's outlined in your judgment of divorce. And so with a modifiable spousal support award, there is the possibility that you might go back to court post-judgment on that issue. Usually we define the term of years that it would be paid for and the amount. But if it's a modifiable award and you reach that end of, whatever your term is, 5-6 years, and there's some need for it to continue, or some changes happened where the payer is now making more money, or has had an influx from a sale of a business or something like that, that would be something that would go back in front of the court too, potentially. And the opposite can happen. So say someone is a payer of spousal support, modifiable spousal support, and they lose their job. Same thing, like they shouldn't be on the hook for paying spousal support when they have no income. So that's something that, like I said, doesn't come up as much by any means as the other two, but it is something that happens.
Now, if you have non-modifiable support, then if it says you pay for 5 years, then you pay for 5 years. You don't get to go back and say, I need more.
Yeah. And it's actually kind of scary when you think about it, which is why you have to be really careful when you're counseling people about non-modifiable spousal support, because if something happens, you are on the hook. I remember having a case years ago where a gentleman, I think my client was the ex-wife, but she was being paid by her ex-husband, and he had a horrible health incident. I believe he had a stroke, and he was completely disabled.
Well,
And he was on the hook for non-modifiable spousal support. And the court had no choice. I truly don't even know logistically how he paid it. But
I mean, it's not like you can't collect on your life insurance with a stroke.
no,
A lot of
no,
times they'll
no.
say life insurance to cover, but if you have a disability,
I mean, I guess you're forced to liquidate some sort of asset, but it's
ouch.
bad. It's something that you should really be aware of when you agree to, which is why it's not as common to agree to non-modifiable spousal support.
Right, I could see that. And it's hard for both parties, right? Because both parties are planning on income.
Mm-hmm.
So, yeah, you almost have to like enforce disability insurance or something, and then no
Yeah,
one can
yeah.
afford to pay it.
And it can be a gamble both ways to a certain extent because, and that's usually what it is, the payee is maybe entitled to more, but they can't take the payer back either. So it's an
Right.
interesting decision to make.
Yeah, that does not make it fun. And what about the other thing that I hear about, if you can comment on this, is it seems like kids are going with the spouse that they visit with more, that they don't live with full time. And then there seems to be drinking involved or drugs. And it seems like the parent that they live with is worried that the parent that they're with all of a sudden is driving drunk or doing things like that. And then it seems like your hands are almost tied.
It's tricky. So I mean, those are the vast majority of, I feel like, parenting time modifications. Or you agreed to some sort of parenting schedule and one of the parents is struggling with some sort of issue. And the burden of proving the threshold issue that there's been a change or proper cause is on the person filing the motion, trying to modify that parenting time schedule. And what proof you need to provide, obviously, is a case by case basis. But what if your only proof is what your 13-year-old is telling you? Which oftentimes that's all it's going to be. It's not like you're going to have pictures of empty bottles of alcohol. I mean, that's just not what you usually have. Or maybe they don't have a criminal record. They don't have OWIs.
Right.
They might still be drinking. It's a very tricky situation. And that's why you have to, and that in those cases, it's good to consult with an attorney and think about the proof issues. Ultimately, a demonstration that someone's struggling with that issue usually meets the threshold issue. But then you go into the best interest analysis, and that's usually done through an evidentiary hearing, which is a much longer process. It's like a mini trial because these are very important considerations, obviously, the court has to make. The children's issues are always like a much more advanced analysis. In both ways to make sure the child's protected and safe and their welfare is being protected, but also you're not taking away one parent's parenting time unfairly, potentially. So,
Right. Depends on which side of the line you're standing on, right? Because they
Yeah.
sound yuck in both
yeah,
places.
yeah, they're not fun. I think that's kind of these are the kind of situations that people think of when they hear, oh gosh, you're, a family lawyer. Like, I'm sorry.
Right, because it's tricky. It
It
is
is.
very, very tricky. And I'm glad there's not a lot, but every once in a while you get oh, my neighbor, my relative is an attorney, even though they don't do family law, they said they can handle my divorce. And it's like,
Mhm.
oh God, there's so many
Yeah.
issues that you wouldn't want someone besides a family law attorney to tackle.
Absolutely. I mean, not to like disparage the jack of all trades type attorney, because I mean, obviously they know what they're doing to some extent too. But I mean, we specialize in family law because we recognize that it's ever changing case law, you got to keep up with that kind of thing. Knowing your judges, your front of the court referees, your opposing counsels, all of that can help. Seems kind of silly, but all of that can help, facilitate a peaceful, collaborative, if possible, divorce for sure.
Anything else that I'm missing that you think we should add?
I don't think so. I think we kind of went over it. Yeah, like I mean, the one thing I maybe didn't touch on with the property issues is that when you sign a judgment of divorce addressing your property issues, those are final and binding, except for like extreme extenuating circumstances of like fraud. So really, you can't, I mean, people will come to us occasionally be like, okay, so I agreed to take this much from his retirement or her retirement, but I thought I was agreeing to this, or I should be getting this. It's not something you can go back to court on. So all you can really do is enforce those provisions. Whether that's the award of a car or, the transfer of money from a bank account. Those are just pure enforcement issues. And one other thing I just thought of, oftentimes as far as the property enforcement issue, and like we talked about in the beginning, not really having the steps, laid out for you. An issue that comes up often is the division or transfer of retirement account funds. We make a point, obviously, to really counsel our clients that when your judgment's signed and your divorce is final and you have a provision that says I get 50% of my ex-spouse's retirement, that doesn't mean it's just going to magically appear in your bank account one day.
Right.
There is a post-judgment process for that entire transfer where you need a qualified domestic relations order drafted, or sometimes it's an edro. And that whole process happens post-judgment. The drafting of it, the reviewing of it, the signing of it, the having the court enter it, sending it to the plan administrator. I mean, it can take weeks, months sometimes.
I've
And
had
I think
people
that's
who have used that as a down payment money,
sure.
and they think, oh, my divorce is final on this day, I could go buy a house. And it's like, oh, no, you really can't. We got to wait for money in hand because there's no guarantee when that money is coming in. Every employer sponsored retirement is different.
Yep. They have their own timelines. They have their own requirements. That's why you need to make sure you're retaining someone who knows what they're doing to draft the quadro. And it really is on us as practitioners to explain that whole process to people. Because I mean, you wouldn't know, of course, you wouldn't know. You think it's part of the divorce. It's something you agreed to. So
right. I explain that process a lot. So I wonder even if hearing it once from your attorney sometimes isn't enough.
And
Do
it's
you ever,
confusing. I mean, it's not straightforward. So
right. And it's a little confusing. Do you ever run into where you guys agree to split a retirement account and then the retirement account company says, nope, sorry, we don't split?
I mean, it more often will happen where the quadro that was drafted isn't the appropriate quadro, because that will happen. Like plans will have very specific language. I don't know that I've ever had it where they've refused. I've had the situation where you go to divide a retirement account and the funds don't exist anymore. And that becomes a whole other issue. Then you have to go back to court and try to figure out where else you're gonna, get that reimbursement from, essentially. So, but most often, and I will say that is, once it's explained to the parties, it's really not very challenging to do logistically. It's just a matter of getting everyone on the same page.
Right. I agree. All right. You were so informative, and I thank you so very much for sharing your knowledge with us.
Yeah, no problem.
If anyone wanted to get a hold of you, what's the best way for them to do that?
So they can call us, they can go to our website, kizzylaw.com. Our emails are on there, our contact information's on there. You can find us on LinkedIn. We do have a Facebook, all of the things.
Okay, so tell me your website address again. Okay, so Kizzy, K-I-Z-Y.
Yep.
law.com.
Correct.
And your main phone number?
248-662-5499.
Wonderful. All right. Thank you so much for your time, Ashleigh. Really appreciate it.
It's good to see you.
You too.
All right, bye.
I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.